The Supreme Court is re-examining a dreadful decision it made 40 years ago that ended up vastly increasing the powers of government. Will the Supremes now rectify this mistake and revive the essence and spirit of the Constitution? Our future freedoms depend on it doing so. Hello, I'm Steve Forbes, and this is What's Ahead, where you get the insights you need to better navigate these turbulent times. The Supreme Court will be deciding two cases that could overturn a now notorious decision it made back in 1984, Chevron versus Natural Resources Defense Council. In essence, the Chevron ruling said the court should defer to actions taken by a government agency or department unless the law specifically says otherwise. In other words, government agencies were given wide berth interpreting how to carry out a law. If there was any alleged ambiguity in a law, the agency could pretty well do what it wanted. The case arose when the EPA, under President Ronald Reagan, reversed a previous decision made by the agency. The reversal prompted a lawsuit against the EPA, and a federal appeals court sided with the suers. The Supremes unanimously overturned that appeals court decision, saying in effect that if there was a legitimate question over what a law actually meant, courts were to abide by the agency's interpretation. At the time, courts in the U.S. were becoming notorious in making law on their own, such as how schools should be run. They were guilty of usurping the legislative branch. The Chevron case was seen as curbing such judicial overreach and abuses. In a classic case of good intentions going very badly, however, Chevron ended up giving the executive agencies vast, unaccountable powers. Presidents who couldn't get particular programs through Congress turned increasingly to federal agencies to enact them instead. Under the Clinton administration, agencies started to twist Chevron as a way to push political policy objectives. The result has been a vast increase in government powers, where we're being ruled not by laws passed by Congress, but by an avalanche of executive orders and agency regulations. Did Congress, for instance, ever pass a law mandating the end of the internal combustion engine for cars and trucks and its replacement by heavy batteries? No. It's being done by government decree. Chevron has also increasingly neutered Congress. Legislators deliberately pass vague and ambiguous laws so that agencies and departments take any heat from how they're actually implemented. Or lawmakers encourage agencies to create programs or render regulations instead of having to go through the hard work of legislating a specific law. Passing the buck and undermining the Constitution. Too much power has passed to federal regulators. The Chevron ruling also led to government inconsistencies, as one administration changes the rules of a previous one. The immediate issue before the High Court concerns whether a federal agency, the National Marine Fisheries Service in this case, can force owners of certain fishing boats to pay the cost of government conservation monitors who tag along on their boats. The litigants rightly say Congress didn't give the agency that power. The Supremes should smash our overreaching, power-grabbing bureaucracies. I'm Steve Forbes. Thanks for listening. Do send in your comments and suggestions. I look forward to being with you soon again.